like to convene the Thursday, February 9th, 2017 Board of Adjustment. Could I get a roll call, please?
Stonebarger's absent. Arnold.
Here.
Hanson.
Here.
Shriver.
Here.
McGuire.
Here.
Albertson.
Here.
Dolly is absent. Stein is absent. We do have a quorum.
Thank you. First item on the agenda is the approval of the January 19th, 2017 minutes. Can I get a motion in a second?
I'll make a motion.
Motion by McGuire.
I'll second.
Second by Arnold. All in favor, say aye. Opposed? Motion carries. Second item on the agenda is the applicant Watertown School District 14-4, doing business as LATI. Is asking...
Right. LATI was requesting conditional use request. Applicant seeks approval to construct a 10,400 square foot, 65 by 160 foot building in the R3 multifamily residential district to be utilized as a flexible training space for any school program in need of lab space pursuant to 21-20031 and 21-14033 and contingent upon compliance with the specific rules governing individual conditional uses. We're kind of getting the cart before the horse a little bit here, but any approval that you make today is going to be conditioned upon the Plan Commission rezoning this R4 zone district into R3, and then it's still going to have to go to the City Council for them to confirm the rezoning to R3. But can I have the overhead ready?
And procedurally, Ken, once this is rezoned to R3, all schools have to come before us for conditional
Right, so
use.
we're still here asking for the conditional use. That's why. But the conditional use is pursuant to those things.
The conditional use doesn't have anything to do with parking, setbacks, anything of that sort, because they don't have a site
There's
plan
no
yet,
variance
correct?
request on this whatsoever. This is totally
Just a
gonna be
conditional
conditions.
use, just to put a school in the R3 zone, with the assumption that it will be rezoned to R3
Correct.
at a later time. All right. With that, I'll open the public hearing if anyone's here to speak on behalf or against the conditional use.
Was public notice. We have been not contacted by anybody. And you can kind of see this is,
How many adjacent landowners were there? Any idea?
yeah.
That's that old mobile home park that there are no mobile homes back there anymore.
There's 5 adjacent landowners. Right. Currently, this parking lot now exists, as you see it here today. They're proposing to put in this parking lot, and the building they're going to put in is right here. This building actually has an alternate for this part here, but we're just asking for the entire thing to be done at this time. So if they decide to do that alternate next year, a year later, or whatever, they don't have to come back before you. Because again, even with that part of the addition, there's no variance, just meeting all the setback requirements. Other than the conditional use, that's the only reason it's here.
Okay. Thank you. Is anyone else here to speak in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and second for discussion.
I'll move.
Motion by Mr. Arnold.
Second.
Second by Mr. Hanson. Any other discussion on it? Any questions? It's just a conditional use, not a variance of any sort. Seeing none, I'll ask for a vote. All in favor, say aye.
Aye.
Opposed? Motion carries. Item 3, Larry and Barbara Rayfield. Seeking a variance at the property at 698 North Lake Drive.
Mr. Chairman, a point of clarification, if I may. You referenced that this particular proceeding involved a variance, but I would acknowledge that this particular item on the agenda for the Board of Adjustment relates to an appeal of the decision of the building official. And with the building official here, perhaps as a brief preface before Mr. Rayfeld can give his side of the story, I'll have the building official give his background on this particular matter.
All right, this is, again, Larry and Barbara Rayfield, address is 698 North Lake Drive. Applicant's appeal, the building officials ordered to remove a non-conforming porch that was unlawfully constructed and attached to a single-family dwelling located in the R1 single-family dwelling district pursuant to 210202-1B. Right to appeal concerning interpretation or administration of the ordinance as the decision of the building official. Again, for a little bit of history here, on 7/8 of 2009, applicant was submitted to build a house, compliant single-family dwelling with attached garage, submitted site plan approval, plan shown no screen porch, retaining wall, patio, or deck. Site plan with the revision of the retaining wall handwritten along the property line, north property line, was later submitted, data unknown. On 7/14, notice in order to remove the non-compliant, non-lawful improvements, which was the screen porch atop of the retaining wall and patio deck. By 7/3, 7/14, staff meeting with Rayfields offered to purchase part of the public access, or they offered to purchase part. On 8 of 2014, the city council offered to purchase encroached land, was denied. Again, on 8 of 2014, notice in order to remove unlawful structures encroachment by 11/1/2014. 11/2016, notice in order again was set out to remove the unlawful structures encroachment by 22/13 of 2017. And again, 12/16, formal clarification of notice of order in the letter. Where'd my mouse go? It's right here. You can actually see on this picture here, the area we're talking about is this screened-in porch area right here. The property line on this parcel falls right along this boundary wall right there. And there was no permit issued for that construction of that, and there was no, and of course it sets into the side yard setback. The applicant is here to defer that I went in question with that. So that's where we're at.
Ken, I was reading through all your notes and letters and try to get a handle of what we're looking at here today, but what, in purchasing the land from Mr. Hanson, how does that all tie together with this?
Oh, that's really not what's in question at this time, though.
Okay.
Basically, all that's in question, all that you guys have the right to decide on is whether that I acted correctly or incorrectly with regard to the ordinance when I asked him to get a permit and remove that property from the setback. That's the only point and issue that you guys have the authority to decide over today.
Okay.
With that, I'll open the public hearing.
I'm sorry. What?
You just opened the public hearing, so you can speak.
Okay, thank you. Appreciate being here. I'm Larry Rayfeld. I'll have some prepared remarks, if you will. So, first I wanted to present, would you put up the first slide, please?
Certainly. Let's see here. So this would be on
That's the aerial one that we have.
Adobe? Okay, so is this the one?
Sorry,
Or,
nope, next one.
okay. Right
Okay.
here.
Okay. In 1972, Dr. Hanson, which owns the entire area that's outlined by the blue, that included the rather long right-of-way in the white up there. At Dr. Hanson's request, the city vacated that original right-of-way in exchange for creating the new right-of-way, which is Lot 23 and 24, which is in the dark, in the black. Shortly after that exchange, Game Fish and Parks took control of most, but not all, of the new right-of-way. A pole and wire fence was erected defining Game Fish and Parks area, which excluded the small triangular piece of land adjacent to our lot. If you'd switch to the second slide, please, Justin.
Sure.
That small parcel, outlined in blue, was occupied and cared for by the various owners of Lot 22, which is where our home is. Given the law at adverse possession, this parcel became owned by the owners of Lot 22 once the 20-year requirement was met and was no longer owned by Dr. Hanson. So why are we here today? We received a permit, as Ken said, for our home in 2009 and was approved for final inspection by the city in 2010. 4 years after that approval, we were served with a complaint ordering us to remove the retaining wall and the screen porch. As the first notice required, we met with the city staff and believed this issue could be easily settled once our facts were presented. I was mistaken. Over the past 2.5 years, we have proposed numerous options. The city council refused to meet with us, have made all their decisions in executive sessions. We were really left in the dark and denied due process. Our most recent effort last summer, Attorney John Wiles, on our behalf, met with Mayor Thorson, agreed on yet another compromise. which was again rejected by City Council in executive session. It wasn't until we proved to the council that they were violating their own ordinances in that they did not inform us in the first two complaints that there is in fact appeals process and that process must be an open meeting. Then the city repositioned their complaint and designated you folks to hear our appeal. Now to the complaint. As I understand in Ken's letter of January 25th, which should be in your packet, the retaining wall is not now an issue. That's, I believe, correct, right, Ken? We're talking about the screen porch.
Correct.
Okay. So the single question before this board, does a temporary screen porch require a building permit or does it violate the setback requirement? In the International Residence Code, I feel like I've gone to law school in the last few months here. Under section R105, work exempt from a permit. One-story detached accessory structures such as tool and storage sheds, playhouses and similar uses, provided the floor area does not exceed 200 square feet. Our screen porch is under 200 square feet. It is used only.
Can I interject with one little thing though?
Sure.
When we adopted the code though, we didn't adopt that section.
What, the entire
The
section?
200 square feet, you are required by our ordinance to do that. That was denied when we adopted the code.
Oh, okay. Well, forget that little issue. Our screen porch is only used 4 months out of the year and is stored in our garage the rest of the year. It takes two people about 2 hours to take it up and put it down. By contrast, there are carports in setback areas that are permanently fastened to main structures and have footings, which neither do we, nor to mention the jungle gyms, tree houses, storage sheds, and dog kennels, all of which do not require a permit. Our screen porch is not a three-season room, as the city presents it. It's a temporary screen porch used only 4 months a year, and it's no more intrusive than the hundreds of docks and lifts that sit in side yards around the lake for 8 months out of the year during the winter. To say it violates a side yard encroachment or is a structure worthy of a permit is a huge stretch. All we have wanted is to be treated fairly. Ask yourself, what harm is a temporary screen porch causing? How is prohibiting us from using it for the 4 months possibly violating any law or even an issue as city government is concerned? And I want to add a part here too. I want to add that in no way do I blame Ken or feel that he has not done his job. This absolutely has been driven solely by the city council. There was another section, okay. Okay, leave that out. You folks are essentially the judges. You don't work for the city. You're to be impartial, and we have been putting up with this for 2.5 years. Denied our rights, denied all this. We finally got to this point, and when I said I appreciate being here, I really do appreciate being here. Given everything else around the lake and the situation, this screen porch is, I don't see how anyone can define it as being an obstruction. We put it up in the summer like anybody puts anything else recreational up in the summer. So I would ask that you be that judge and respectfully request that you dismiss this complaint. And I've got dry mouth, so I need to go get my water bottle.
Mr. Chairman, if I may be able to respond.
Yep, go ahead.
Okay, thank you. Members of the Board of Adjustment, there are a couple of items here at issue that I just want to touch on briefly. Mr. Rayfeld characterizes decisions or concepts addressed by the City Council throughout the years regarding this issue as being done behind closed doors without due process. And I think that's a mischaracterization, because really what executive session permits is discussion with council on matters that are pending litigation. And with the Rayfelds having over the last 6 years, 7 years, had multiple councils, made multiple requests of the city to think about purchasing land, transferring land. These were all issues that needed to be addressed by legal counsel in anticipation of possible litigation as well as in contract negotiations. So the city council did nothing wrong. What's at issue here is an appeals process which, as you know, hasn't been invoked terribly often. The reason why it hasn't been invoked terribly often is because, generally speaking, application of zoning ordinance is a straightforward affair, and it's got a word in the law. It's called a ministerial act. A ministerial act per South Dakota Codified Law 11-4-19 is not something that is appealed to the Board of Adjustment. Rather, what it is it is a filing in municipal court of a violation of zoning ordinance. What we have here, however, is someone contending that the building official's decision is based on a wrong interpretation, is not a simple ministerial act of applying policy and bringing a case before the municipal court. Instead, he is asserting that there are extenuating circumstances involved, other facts, including the ownership of Lot 23, which the city asserts it owns in fee title. And even, I think Mr. Rayfeld admitted in a letter that he sent to the city that the lot is subject to the city's public access right-of-way. Now, the reason why Ken prefaced his comments by saying that we are focused upon the screened-in porch is because Mr. Rayfeld, in order to make his argument, is trying to bring in a separate issue regarding the encroachment. Now, the reason why I suggest to you, not only as counsel for Mr. Buchholz, but also as counsel for this body, that that isn't a concern that is germane to this body's jurisdiction is because that concern rests in who owns the land, in title to the land. And what the Board of Adjustment's role, this is based upon my legal research, is to construe zoning ordinance. It's to, in this particular circumstance, determine whether Ken's interpretation of zoning ordinance is incorrect. So what are we left with in zoning ordinance? We are left with the building application permit, the building permit application, excuse me. That application does not depict anywhere in its 15, 20 some odd pages this screened-in porch. So the question is then, is this something that needed to be permitted? And per Ordinance 21-0206 sub 1, I would argue that it does, purely because this is considered a structural addition to the property. It may be removable, but it is still something that is attached to the structure and can be permanent if the homeowner decides that it will be kept permanently. Also, if Mr. Rayfeld is contending that he put it on after the building permit was issued for his structure, he is still required per 21-0206 sub 2 to obtain a permit for that screened-in porch where there is, again, a structural change in the building. So regardless of the ownership interest in Lot 23, we have the issue of the screened-in porch not being permitted at base. So we can forget all about that, just focus on the permitting part of it, and he, I would argue, is in violation there. The second way that this screened-in porch is in violation, as Ken touched on, is the side yard setback, which is 9 foot in an R1 zoning district as this is. Now, SDCL 11-4-1 allows the city council to adopt zoning ordinances that set the percentage of a lot that may be occupied, the size of the yards, courts, and other open spaces. So what we have in zoning ordinance saying 9 foot setback is required is entirely within the authority of the city to promulgate. Now, again, that 9-foot setback is in our ordinance 21.1001 sub 1. And then going to the definition of setback in our zoning ordinance, you go to chapter 2190. Setback there is defined as, quote, the required distance as prescribed by ordinance, which must exist between any building, structure, or sign and a lot line, end quote. That last phrase is important. A lot line, in this case, is that which exists between lot 23 and lot 22. Indeed, if you look at another definition in chapter 2190, that for yard required setback, it is defined as, quote, that unoccupied portion of a side, front, or rear yard nearest the designated lot line and being the minimum width or depth required in the district in which it is located unless otherwise specified in this ordinance. There again, the key phrase being lot line. I think this board knows that in circumstances where lot lines need to be adjusted, there's a process for that. There's a process for being able to modify your setbacks in a case where you may have bought additional land, and that is through either a plat or replat or through a development lot agreement. And a development lot agreement is defined, again, in Chapter 2190 as an agreement joining one or more lots together as one parcel for the purpose of development. They must be signed by the Plan Commission or its designee. In this case, we do not have either of those two items that are lawfully allow for a lot line to be changed. So what we are left with is a 9-foot setback with the measuring stick being the lot line. This porch, the screened-in porch, clearly is an obstruction in that side yard. I then point you to Ordinance 21.6001, which lists the permitted obstructions in required yards. Sub A and Sub C do not reference any kind of covered porch as being an exception, those being the relevant side yard setback obstructions that are permitted. Now, you may question why it is that we're bringing this up. As Mr. Rayfeld points out, he can take it down, put it back in his house at will. He mentions that it's akin to a dock or a play structure outside. The fundamental difference between what examples Mr. Rayfeld brought up and this particular circumstance, I would venture, is when we talk about structural. When you can have an additional living space appended to your house and willy-nilly decide to stick it on, tear it down, or what have you, it effectively negates your ability to manage ordinances, zoning ordinances under the law. Because if you think about it, somebody else could have a similar modular type of home living space. Just slap it on the side of the house, right? That adds to their square footage, but they never came to you for it. They never came to you to account for the fact that it has impacts upon their neighbors. They could put that screened-in porch right up to the lot line, right past the lot line, as the city would argue Mr. Rayfeld did in this case. So this is not an innocuous thing that Mr. Rayfeld is proposing here, I would argue. Rather, this is a very ripe case that needs to be dealt with by the Board of Adjustment, because it sets an important precedent. What approving Mr. Buchholz's opinion would do is really one thing. It would make this particular requirement that Mr. Rayfeld not put the porch back up a ministerial act for Mr. Buchholz, which would mean that, and I would argue, that if Mr. Rayfeld were to put the screened-in porch back up after, if you decide that Mr. Buchholz's interpretation is correct, that we would then be able to proceed to municipal court with the zoning ordinance violation directly. So that is why I think, again, it's important for this board to address this issue. And I guess I would end by simply noting that ordinance would also bind Mr. Rayfeld to a continuing obligation to keep his side yard free of obstructions per 21 period 6002. And so that is another basis for why the board needs to act to make sure that that ordinance is being adhered to as well.
Thank you. Justin, I have two questions for you.
Yes, sir.
As a legal counsel to this board, do you consider that by our code, is that considered a structure?
Yes.
Second question is, as our legal counsel, is that considered inside the setback
Yes,
based on the legal lot lines that you've interpreted?
that's correct.
Okay, so you
Pat,
say it is inside the
what
setback
was
and it
that?
is a structure.
The last question,
The question I had
the last question you asked was what?
The question I had was, based on what we show as what the legal lot lines that our council says is the current legal lot line, is it inside the side yard setback,
The screened-in porch.
the screen-in porch? And he said yes,
So it's within the 9 feet?
within the 9 feet of the,
I would, to elaborate on the structural point, you have a common definition of structural.
That was me.
That's quite all right. You have a common definition of structural, which from dictionary.com means, quote, of or relating to structure, pertaining or essential to a structure, end quote. The reason why I think that is a proper definition of structure, again, we don't define it precisely in ordinance, but when we don't, and when it's something that is commonly defined, we go to a common definition. The reason why I feel that that is the proper definition of structural is that if you don't view that as the proper definition, where it's pertaining to, relating to the structure, and you say, well, it needs to be the structure. Well, is that a retaining wall or something that's a load-bearing wall? Is that something that is essential to the structure? That's the only thing that we can view as being the four walls of a building?
so I'll rephrase my question.
Mhm.
Based on our building code, is that considered a structure that's required to be upheld by the 9 foot setback?
Because the side yard obstructions permitted do not include this, but do reference a patio that is not covered, or, let's see here. So we're talking unroofed open terraces. Those are permitted in all yards. For side yards, we're talking overhanging eaves and gutters. And we're talking this screened-in porch has a roof, very, very similar to what you see on the structure itself, on the building itself, that is attached. Can be taken off, but it is still attached for a full season.
I got a question.
I've got a few. Go ahead. You go first.
Do they have footings out there?
On
No,
this,
there's
on this
not.
structure we're talking about? No.
Yeah. There's no footings?
He's just set on top of the patio. One other comment. He's not here to ask you guys for variance. He's just asking you whether the determination that I made was correct or not correct. If he wants
Correct,
to come back
correct.
before you and ask for a variance, that'd be a separate issue.
Correct. He's not asking for a variance. We're just here to determine whether the building official acted correctly.
Okay. You done, Jason? Is that
I guess I am now, yeah.
Matt?
so? The screened-in porch does not have a foundation underneath it. Okay, it's on a. It's on a. Was it put on the house when the original house was built?
No.
But underneath the screened-in porch is a patio,
Right.
and that patio was used simply as a patio at one time?
Correct. And it still
Okay.
essentially is.
Is there access from the house into the screened-in porch?
Yes.
So there is a door.
Yes.
So once you put it on, you can come out of your house into the screened-in porch?
Correct. I'd like to clarify. Are you done?
Absolutely.
Okay. I want to clarify something in terms of the city and saying that using executive session is appropriate because we had legal counsel. We did not have legal counsel until we got to a point where we were totally frustrated. The first complaint served on us said, essentially tear down the retaining wall, tear down the screen. I don't even know if it mentioned screen porch. It probably did. The real issue that the city is addressing is they think that the retaining wall is built on city property, and they don't want anything built on city property. The screen porch was really not ever an issue. It wasn't the real reason for what they did. The complaint did not have an appeals process. And I asked the then city attorney, I said, Ken has authority, but he doesn't have authority to throw me in jail. And that's also, by the way, attached to the complaint is your penalty, and it can be up to 30 days in jail. I mean, we got this cold one day. I worked with them. I thought, once people understand, we followed the fence line that had been there for 45 years. We weren't building on city property. We weren't trying to take away city property. We were never allowed to present that information to the city. We did not have an attorney, but they made decisions during that time. We have letters saying the city decided to do this. That's a decision. And from what rumors I heard, there was actually votes taken. It wasn't unanimous. So there was a frustration of saying, tear down your retaining wall, guy, and there's no other recourse. And frankly, for that year and a half, we tried getting this dialogue going, but every time I'd leave home for a few days and come back, I had my first thing I looked at was that retaining wall to see if the city had plowed it under. I mean,
But today we're not talking. We're not even visiting about the retaining wall. Today, this
I know
this
we
board
are, but
wants to look
please
about.
understand the history of this. This is why the city has been so adamant about this. I don't believe the city or anyone does really object to our screen porch.
This board may.
Oh, you do now.
Well, this is a board that upholds zoning ordinances and setbacks.
I understand.
Every twice a month we meet when people try to build within the setbacks.
And I would just clarify, too, that the original letter dated July 2nd, 2014.
Didn't have the screen porch?
It says, since then, non-compliant and unlawful improvements have been made to the property, i.e. a screened porch atop a retaining wall and patio/deck, all of which required building permits prior to construction, end quote.
So up to January 25th, when Ken redefined what he was doing with the retaining wall, we were supposed to tear that down. That's why we decided we needed to discuss this. We were not, the city law requires the city to put an appeals process in there. When we pointed that out, then things, as I explained, then things changed. So we were able to get in front of you. I disagree with Justin's definition of a structure. It's a roof similar to the roof of the building. No, it's a canvas roof. It's screens that we had Dakota Window build that sit up, put a canvas roof over it, and we use it during the summer. To say that's a structure, it's not a living space. It's not, when I look at what's exempt from building permits, playhouses are mentioned and that type of thing. It would really fall more under that. It's not attached to the house. It's an independent structure. I do have 4 thumb screws that I do hold the canvas up on the house. That's hardly saying it's attached, hardly saying it's a structure. Now, if you as a board have the standards set where something setting temporarily in a setback area is a violation, then you really can't ignore docks and lifts, boat lifts, which many are set inside back areas. And it's the purpose of not blocking a setback area is, they're longer, they're more structural than what we have. Theirs doesn't come apart and, get stored in the garage. So I can understand why this is here and why you're saying it's a structure and it violates this. But I think we have to look at the fairness of it and the standards of the community. And in no way this should be an issue before this board.
Okay, well, I tell you what, I think we've heard enough on it. I think we've got a pretty good background on it. We'll have some questions. Is anyone else here to speak in the public hearing? Seeing so, I'll close the public hearing. Ask for a motion and a second for discussion. What the motion is to uphold the building official's decision to have that removed. He's not here asking for a variance to put the structure there. He's here to appeal the building official's decision to ask him to remove that because the building official views it as a structure that's built without a permit and in the side yard setback without a variance. That correct? So the motion will be to uphold the building official's decision.
You need to have a motion.
We need a
before
motion
discuss.
before we
I'll
discuss
make a
it.
motion. then.
Motion by Mr. Arnold to
Second.
uphold the building official's decision, second
Second.
by Mr. McGuire. Discussion.
I understand what we have to act on here today, I understand that, but the other side of this is what I'm trying to get clear here is what requires a building permit and what doesn't. And Ken, maybe I need to ask you, if I have a am I allowed to have a patio on the side of my house in a 9-foot setback, concrete patio?
Covered or
Yes.
uncovered?
Okay,
Uncovered, yes,
okay, that's
without a permit.
without a permit, okay. Now I want to go buy an awning, which people have around town. I want to screw that awning on the side of my house, and when it's sunny, I want to pull that awning out. But then, of course, the mosquitoes get bad in the evening, so I maybe want to pull a screen around that. Does that require a building permit, and does it require a building permit, and is that structural?
Your awning's gonna be attached to the house, correct, and then rolled out. I say as an awning itself, if it expands beyond 2 feet on the side yard, then it's illegal, because our side yard only allows for up to 2 feet of an overhang, whether it's an awning or an eave or whatever.
Okay,
If it's
so
in a front or backyard, you can go out to 5 feet. And then once you touch the ground with any kind of permanent pole, then that becomes the base foot of your building or structure.
And that's
Just
the way
like a
our
deck. As soon as the deck posts touch the ground, that's the point of the structure.
that's the footprint of the structure.
Correct.
So if we look and think we may have moved into an area where there's certain types of, I'm going to say, pseudo structures that may be able to be in the side yard that we would think would be conventional and normal, we have to change our code to approve those to be put in that side yard. We have to modify our code a little bit if those are to be allowed in that setback. But at this point,
So-
they're not part of our code.
Well, right now, you couldn't go like and buy a canvas tent structure, to harbor a car or a four-wheeler or anything like that. Stick in your backyard. Those are strictly prohibited by our code. You are not allowed to put canvas structures up. Now, if you've got a kid and he's putting up a tent and he's leaving up for a week, that's one thing. We're not gonna bug you about that. But if you put a structure up, a canvas structure, 4 by 10 or 10 by 20 or whatever, those are prohibitive. We've shut those down many, many times throughout the town.
I've had personal experience with that particular.
If they're
type of structure.
if they're freestanding, they're permissible. If they're attached to the building, they're not.
No, I'm
Neither
thinking
one.
freestanding canvas structure is not allowed either. I mean, if you
Okay.
got some kid putting up a tent or whatever, we're not gonna come and bug him about a tent like a plate is exempt. But a 200 square foot shed, you gotta have a permit to put a shed on your property too.
Okay. Well, that's why I asked those questions. So anything that extends out further than the overhang or further than 2 feet, if it's attached to the house,
In the side yard.
in the side yard, okay, encroaches into that 9 feet and would require a building permit.
By our current.
And then that would
ordinance.
have to be shown on the blueprint of the house when it was brought in to get a building permit.
If I could ask Ken, how do you work with the lifts and the docks and stuff that are stuck with there?
That's personal property.
Justin,
That's my understanding. The only thing that we have in zoning ordinance relating to docks, if you will, are boathouses, which we've had before this body.
But FYI, we are writing an ordinance with regard to those right now.
say Justin, what might clarify things is define real property compared to personal property. That'll do, real estate 101.
Sure. So real property is the land itself. Real property also includes buildings, structures thereon, and it also includes improvements that are erected. Trees, for instance, can be viewed as real property. What's personal property is something that can be essentially taken with you. Now, this is very 101, but it's things that are not of a building or structure, but are rather like a car, a boat, boat lifts.
Would you say things that aren't permanently attached?
That's correct.
Okay.
That is exactly correct. In fact, that's why they call, they use the word attachments in a lot of real estate contracts to describe what's going with the land.
Thank you.
I thought
Any-
that would clarify if you had an awning, Dennis, that's attached to the house, that becomes real property.
I think so.
Right.
Or a ceiling fan or.
Speaker, outdoor lights.
Yeah, anything that's permanently attached.
Any other discussion? Any other questions?
But Larry can come
May
back.
I ask a question?
Larry could come back and appeal, or not appeal, but could come back in.
Request a
and
variance.
ask for that.
Or we could also take a look at our ordinance and if things of this, like this, are something that we're starting to see more that are being put up temporarily and used temporarily, maybe we need to take another look at our ordinance to allow them.
Both of those options are within your wheelhouse, for sure.
Right, but what's here today is a vote to uphold the decision of the building official as our ordinances are
Whether-
written
Current
today,
ordinance.
Whether Ken acted based on the ordinances.
Yeah.
that he has to work with, so.
May I get a sense, since, I mean, you've
I'll-
certainly heard everything
The
about,
public hearing's closed, but I'll let you speak.
thank you. Would you entertain a variance then, if that's the route we should go?
If a variance is applied for, we entertain them all.
That wasn't quite the answer.
We approve some and we
You feel
disapprove
strongly
some.
Both ways, right?
Yeah.
Well, and part of it is, we only have 4 people here tonight. Normally, we'd have 7.
Yeah.
So, that, I don't know how how the rest of them would feel either, but.
Well, I
And,
get-
and then the length of it, I would look at it, if, let's say you came back with a variance, I think we'd have to consider you putting it up for 2 weeks because you're going to have a family reunion, or you're going to put it up the 1st of May and take it down the end of October.
Normally, we do this latter, yeah.
Yeah.
All right, thank you. Any other discussion? Seeing none, I'll ask for a vote. The vote is to uphold the building official's decision. All in favor, say aye.
Aye.
Opposed? Motion carries. Any other old business, Ken? Seeing none, ask for motion to adjourn. Motion by Mr. McGuire, second by Mr. Arnold. All in favor, say aye. Opposed? Motion carries. We'll convene the Plan Commission meeting shortly.
Yeah. For a hot minute, then I need it back. Yeah, I'm more of a Gothic. I tried doing it on the resolutions too, but that was a no. Hmm? Yeah, we got some good stuff. Yeah, I know. Well, it's not on the agenda. It's old business. Yeah.
Are you ready, Brandy?
Yep.
Let me find my stuff. It's here somewhere. I'd like to call to order the Thursday, February 9th, 2017 Plan Commission meeting. Roll call, please.
Arnold. Here. Hanson.
Here.
Shriver.
Here.
McGuire.
Here.
And Stonebarger, Albertson, or no, not Albertson.
Stein.
Raleigh and Stein are absent.
Thank you. First item on the agenda is the approval of the agenda. Could I get a motion in a second? Motion by Mr. McGuire. Second by Mr. Arnold. All in favor say aye.
Aye.
Opposed? Motion carries. Second item is the approval of the minutes from the January 5th, 2017 meeting. Motion by Mr. Arnold, second by Mr. Hanson. All in favor say aye. Opposed? Motion carries. Third item is a resolution amending Title 21 City Ordinances in regard to gambling and casino establishments.
Where is Justin? We'll get Justin. But this proposed ordinance revision to section 21-2403 would eliminate any unlawful preemptive zoning restrictions on casinos and gambling. And then I'm going to turn it over to Justin Getz to explain the background of this request.
I apologize. I just had to step out for a second.
I'm sorry about that, Commissioners. So the genesis of this proposal before you came from some research done on another item for the city. There is some question as to the way that gambling establishments and liquor licenses intertwine. And in doing some research on the issue, I came to find case law from 2011 from the South Dakota Supreme Court, which established that municipalities could not regulate gambling institutions. The court in this case, this 2011 case, construed a Sioux Falls City ordinance, zoning ordinance, much like what we have here, and sided with the Department of Revenue. The Department of Revenue contended that the ordinance was invalid because it invaded the sovereign prerogative of the state. The state argued that gambling is their jurisdiction, that they have, in legal terms, preempted the city's ability to regulate in that area. And the court agreed. The court did note, however, that there are two places, and I think I note that in my memo, two places where the city effectively retains the ability, effectively, to help dictate where these gambling institutions are located. First, there is still the ability of the city to determine locations of alcohol licensees. And that, because the gambling license is effectively attached to the alcohol license, it's a certification attached to the alcohol license, that allows the city to be able to regulate placement. There is also a statute that the city council can reference whenever there is an alcohol license with a gambling certification before it. And so there are options available to regulate it. It's just that when we have in our zoning ordinances unique regulations that pinpoint gambling institutions and say either they are excluded uses or they are conditional uses, that is a regulation that invades the province of the state, according to the South Dakota Supreme Court. So that, for that reason, I suggested that those references in our zoning ordinance to gambling and casino establishments be struck.
So we can't govern where casino and gambling establishments can be. I see we're taking them out of the conditional uses, and then they're in the accepted uses in C1, C2, C3, and the gateway overlay. What about R1? Can they go in R1 then?
See, you point out a very good point. That was initially my concern that, well, if it's free reign, that doesn't augur well for the city. But the fact remains that location is still able to be regulated on the alcohol licensing side.
Unless I want to put a casino up. I'm going to just put a tanning shop and a casino. And I want to do it in the R3.
Can I talk?
Go ahead, Luke.
Okay. I didn't know if you'd open the public hearing. That was the question. Luke
I'll
Pollard,
do that.
First
I'll
District.
open the public hearing.
Thank you. Same thing. One thing that I would venture a guess, and I don't know if Justin would agree or not, I would say that it's entirely likely that you would figure that a casino, based on what state law is as far as what you can and can't do in reference to that, a casino would be considered an accessory use at that point to a bar or tavern. And that's basically it. That may be something you may want to list into your ordinances, that they are considered as a accessory use to those things, but I would say that that's probably the most likely. Whereas you would not expect a casino or bar necessarily, or a casino as an accessory use to a tanning salon.
I would agree with Luke's assessment. He just put it in more zoning terms what legally is the case, which is the gambling certification is attached to alcohol, and it wouldn't be attached to tanning or any
A
other
home
kind of use.
occupation.
That's correct.
Has this been challenged, or why is this coming up?
The reason why this is coming up, Commissioner, is literally I came across it in my research on another topic for city government. That's the only reason why I'm bringing it up. It was a 2011.
The reason I ask that is because there's a lot of court cases and things around the country where certain you name it, organization challenges something and it gets changed. The city of Watertown, I think the residents of Watertown have liked our ordinance the way it is. That's why it's in place, I assume. Nobody's challenged it. Why do we have to change it unless somebody challenges it? That's my question to you.
That's a very good question, Commissioner. My role as city attorney is to be the chief legal counsel for the city, to protect it from assertions of or potential court challenges to whatever it does, be it ordinances it passes, be it actions taken by department heads. So when there is a framework of law that has been found to be invalid on its face, I am charged with ensuring that it gets off the books if I see it. As an attorney, and that's my obligation, to make sure that state law is adhered to, the Constitution of the United States and that of South Dakota is adhered to. If indeed my interpretation is incorrect with regard to this ordinance, I wouldn't put, I would certainly say it's a possibility. But after consulting with the chief legal counsel for the Department of Revenue, he verified my analysis.
I'm going to go back in time a little bit on a personal experience. It's been several years ago, but when I was in the school system, years ago I hired a music teacher. And Watertown has always, it's a pretty traditional conservative community, and many or most all of our Christmas programs had some resemblance of the real meaning of Christmas. Okay? My new music teacher right out of college that year brought her program into me, and I read through it, and she said, this is what I want to do for our music program, for Christmas program this year. And it was a cute little program, but nothing at all about the real meaning of Christmas. And I challenged her on it a little bit, and I said, why, I would prefer that you would find one that, reflected the real meaning of Christmas a little bit more. Well, we can't do that because in Sioux Falls, there was a court case, and they were struck down, and they had to cut them out. I said, I believe the people of Watertown prefer to have a program like that, and I said, as far as I'm concerned, we'll keep doing it until somebody tells us we can't do it. And we did it for years, and probably still doing it. We're singing Christmas carols and things in school programs. So that's why I challenge you with it. Just because it came up someplace else, I don't think necessarily means that we have to change it.
And if I may,
That's just my personal opinion.
Sure.
But
And if I may, Commissioner, I, on a personal level, empathize with this viewpoint, and I can tell you that the reason why the Department of Revenue, I feel strongly about this, the reason why they challenged this, the reason why they had the court establish this in law was the very concern that you just touched on. if localities were allowed to determine where gambling establishments could be in the state of South Dakota, there'd be a lot of quote-unquote dry communities, if you will, for this kind of, for gambling establishments, video lottery, scratch tickets, you name it. That's the reason why, based upon that 2011 Supreme Court case, the court basically said, this is written in the law, this was written back in the 80s for that reason. These forebears at the state level saw the writing on the walls and saw that municipalities would have issues, certain municipalities maybe more so than others. But in order to ensure that this was provided statewide, municipalities couldn't butt in and occupy the field of state regulation that they had set for themselves. It really comes down to who is the supreme law of the land. And even though my personal views may go against what is embodied in what I'm suggesting here, I'm charged with ensuring the Constitution of the United States and the state of South Dakota are upheld. And that's ultimately what I have to act on here.
Well, it was triggered a little bit by one of our conversations at one of our Tuesday morning meetings when we had a request in the Gateway District for somebody to put in a casino license, and we denied it to him and said, well, that's prohibited within our ordinance. And then part of that is when Justin then did a little more research and said, guess what? We can't say anything. They can't have it. City Council might be able to regulate it by adoption of the liquor license, but
Up to this
that
time, when
was
somebody
part of
wants
that
to,
trigger.
up to this time, when somebody wants to put a video lottery establishment, and it always has come to the Plan Commission, and we've said, yep, it's an applicable use in the zoning ordinance, and then it goes to the City Council for the alcohol side. So we've had two boards that had different sets of eyes on the same.
And we'll
Now
still
we
be,
won't. No, they won't have to
we'll
come
still
to
be,
us for any
We'll
reason.
still be having to do the ground because we still have to ensure that within the zoning ordinance it's more than 100 yards from any church, school, state,
That's correct.
But
school
that,
thing.
that's
So
done
we still
in.
have to bless the ground before it can go to the city council.
So if a new video lottery establishment wants to come into a new location where it's not currently at, it still has to come before the Planning Commission.
That's correct. Yep. And we'll still have to do our research and then bring it forward to you. You're still going to have to bless the ground before it
So
goes to
we,
the city council.
we still get to look at it.
We're still so many feet from a church and daycares.
That's correct.
That adheres closely.
That's my concern.
Okay.
I guess, is that all of a sudden one goes right next to the church downtown.
No, it would have to be associated with a bar tavern use. It would have to be. So you would be able to regulate its distance from churches, daycares.
So you can't have a video lottery in a convenience store that doesn't have a bar or tavern?
That is my understanding, yes.
All right. Anyone else speak in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and a second for discussion.
I'll make a motion.
Motion by Mr. McGuire,
Second.
second by Mr. Hanson. I agree with Dennis. Sometimes I look and go, I don't want to change all our ordinances unless we have to, because it allows the common people of the community and multiple boards to have their eyes on something, and we're less likely to make mistakes the more people that look at it. But in this case, you're assuring us that it still will come before two boards, the Plan Commission and the City Council?
It will as a result of the fact that it is tied to an alcohol license.
Okay.
Everything that you would do with an alcohol license, you would continue to do.
Then I would recommend we make a motion to approve it with the assertion that all video lottery licenses in the city of Watertown are linked to an alcohol license. That way it comes before us.
That was what I was told by
Okay.
the Department of Revenue.
I think if it's in the motion that that it is linked to an alcohol license, so they can't fly under the radar, and that we unintentionally have one put where we don't intend it to be. So the motion would be to approve it as written, with the guarantee that they will be linked to an alcohol license or a beer wine license of one sort. Do I have a motion?
I'll make that.
Motion by Mr. Arnold, second by Mr. Hanson. Any other discussion? All in favor say aye. For the record, Mr. Dolly is here. Fourth item on the agenda, I'll make sure I'm on the right spot. Fourth item on the agenda is the annexation and zoning of Rogers Outlot Number 2. I think Dennis on that now. We couldn't have accidentally missed it. That doesn't have to be a link to alcohol license.
Okay, so we'll start with the annexation and zoning of Rogers Outlot number 2. The petitioner submitted an application and petition on January 11th, 2017, requesting approval for annexation and C3 highway commercial zoning. The adjacent zoning designation is also C3. The adjacent public right-of-ways will be included in the annexation and zoning of the property. It meets all the requirements of a C3 for a C3 minimum lot requirements. Municipal utilities will provide service to the annexed property. There's 4.1 acres involved. It is not in the floodway or floodplain and does not need park dedication since the proposed zoning is commercial. And staff recommends that the Plan Commission approve the application to annex and zone the above said property.
Thank you. With that, I'll open the public hearing. This is the property we talked about a couple weeks ago, out by the interstate in the area of McDonald's.
Yep.
See Mr. Folkerts is here. Any changes from what we talked about before? Everything is as we said before? Okay. And what we're doing right now, we're not looking at any plats or any lots or anything. All we're doing is we'll have two votes. First on the annexation into the city limits of Watertown, and second is a C3 zoning. And everything around it is already C3, correct? Little business park on one side?
Yep.
And it is adjacent to a major highway.
Yep.
Anyone have anything to speak on behalf of this in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and a second for discussion.
Make a motion.
Oh, come on, I'll reopen the public hearing, come on up.
We can do that for the preliminary plan.
Oh, that's for the preliminary plan, not for the zoning and annexation. Okay, I'll leave the public hearing closed. I have a motion by Mr. McGuire. Did I have a second? Second by Mr. Dolly. Discussion. We looked at this a couple weeks ago. It looks like it's C3 highway commercial. No questions. I'll ask for a vote on the annexation. All in favor say aye.
Aye.
Opposed? Motion carries. I need a motion and a second for the zoning. Motion by Mr. Dolly, second by Mr. McGuire. Any other discussion? Zone C3 commercial. All in favor say aye.
Aye.
Opposed? Motion carries. Item number 5 is a preliminary plan for New Venture 3rd Edition.
Okay, so then this is what we brought to you guys as a discussion item last meeting on January 10th. So the petitioner submitted preliminary plans on January 26th requesting approval of New Venture 3rd Edition. This plan has been brought before you previously as new business during the January 19th Plan Commission meeting. Scott Calvert of Austin Engineering and Bill Folkerts made some changes to the preliminary plan. They are proposing approval of the preliminary plan that was conceptually brought to you at the previous meeting for discussion.
And we had some handouts that were, is this the updated one, or is
Yes.
this the same as what's in our packet?
Though that's the drainage, we'll address that too.
Okay.
They brought in some revised drainage plans. And then Calvert addressed concerns mentioned by the board and took into consideration their recommendations. So I'll pull up the plan. Okay. So the facts about the preliminary plan, the adjacent zoning designation is C3 commercial, and it's going through the annexation and zoning process. It meets, the lot areas meet the regulations for a C3 district. The plan will create 6 lots, and lot 4 is the detention pond which will be dedicated to the city. Proposed 60-foot right-of-way in conformance with adjacent developments. City standards has been 66 foot for public right-of-ways, but that's one of those things that we talked about. Since it conforms with what's existing, that's something to keep in mind. Proposing 36-foot public streets on proposed 35th Street Southeast and proposed 7th Avenue Southeast. And then proposing a 28-foot private drive on lot 6, right there. Proposed 35th Street Southeast will make the existing structure of Quality Inn and Suites non-conforming by not meeting the 40-foot front yard setback, as it will become a front, as required by zoning ordinance. To obtain building rights to Lot 5, property owner would have to receive a variance from the Board of Adjustment if he would want to make improvements to that building. And sidewalks are proposed for one side of the street, which is non-conforming with ordinance 240510, stating concrete sidewalks shall be constructed along each side of every street shown on the plat. They're showing sidewalks to come along that jog there. And in front. Okay, the 100-year floodplain is not present on site. Detention pond is required to hold 2-year capacity volume for Willow Creek watershed. And the BMP development agreement for stormwater pond will be made between New Venture Inc. and the city to ensure maintenance is accounted for. So this is the plans. With that, I'll turn it over to you.
Okay, I'll clarify a couple things as well. So what I just want to briefly point out is what has changed since the previous concept that you looked at is, if you notice where the private drive goes north and south along the western edge of this plan and then turns into 7th Avenue Southeast, that became a turn instead of the previous version we brought before you had a roadway going to the west. And the developer was able to prove through his engineering team that two things were impractical about that. We were going to create a lot that originally was maybe going to be earmarked for a potential stormwater pond. They couldn't find that the stormwater pond would be feasible in that location. And so we as staff had concern over forcing them to have a non-compliant lot that wouldn't even be sellable, wouldn't fit within this C3 district. So then we revised our plan to make that a curved intersection instead of proposing a street going back to the west. I just want to make that clear why that changed, because I didn't want to create a non-conforming, unsellable lot. So we just incorporated that into the lot 1 so that he didn't lose land unnecessarily. The other thing that, go ahead.
Well, I was going to, on the streets, did we have 60-foot wide right-of-ways at that time too?
Yes.
And one sidewalk on one side?
Yes. Well, that was what he was bringing forward. So one of the other things that changed is that on his previous version, they requested a 32-foot wide street width, and we did not deny that at the time, but what I did do is request that they review to make sure that the size of vehicles and the turning movements could be accommodated with that proposal. And what they found was that they needed to do a little bit wider street section, so we have a proposed street width of just over 37 feet wide now.
And the concession was also no parking on those streets.
Correct. But I just wanted to acknowledge that that's the work that's happened since you were last reviewing this plan. Okay?
Why are we not requiring sidewalks on both sides?
He's requesting that we vary from that. That's a decision that
Point
you'll
out
need.
where the sidewalks would not be.
Well, I just brought this up for reference. This is the plan that we brought as new business. And then this is the plan we're looking at today. But where the sidewalks will be is where I pointed out there. Otherwise, there will not be sidewalks on the existing roadway.
I mean, this
is private.
Okay, so that's what he's proposing is for sidewalk there.
So on lot 6, when that's developed, will there be sidewalks on lot 6?
Which one's lot 6?
The big one in the middle. We don't know what's going to be there. Could be a restaurant.
We don't know what's going to be there.
But I'm not comfortable saying you don't have to put sidewalks there.
know what's gonna be there, I don't see a purpose in trying to.
Right, I'm not saying you have to put them there now, but when it's developed, will he have to come back before us to get a waiver for those sidewalks if they choose not to put them on Lot 6 at that time?
Unless you incorporate it into whatever you accept right now that says it wouldn't be required. Otherwise, if you don't say specifically they're not included there, they would be required at the time of a building permit, and they would
Okay.
have to come before you then to ask for a
Okay,
variance at that time.
so as long as, once we see how that's developed and what's there, the assumption is there will be sidewalks on that. We're just talking about the sidewalks that are on the current diagram. Okay. Anything else, Brandy?
No.
Public hearing's open. I think we had somebody that wanted to speak in the public hearing.
My name is Gam Patel, and I bought from Bill like a 2015 Country and Suite, and I have on purchase agreement like a no compete. So I don't understand why he tried to build that, because we have on purchase agreement 5-year no compete on agreement.
That's nothing that this board takes into consideration. I'll defer that to Justin, and he can direct you to where he would think that would go.
Mr. Patel, the jurisdiction of this plan commission is to look at uses in the community, to look at plans, to see if they comport with our laws regarding zoning ordinance. The matter that you're discussing is a contract concern, and contractual matters are generally dealt with in circuit court. If there is an issue that you have about whether this is transgressing the contract provision or not, I would suggest obtaining counsel and pursuing your options that way. Unfortunately, here we are not able to. Well, the plan commission, it doesn't have the jurisdiction and would not be able to act upon that concern.
Thank you.
Sir.
Thank you. Is anyone else here to speak in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and a second for discussion.
I'll make a motion.
Motion by Mr. McGuire,
I'll second.
second by Mr. Arnold. Any other discussions other than we just want to make it clear that we didn't waive the sidewalks in Lot 6?
Okay, so one other item that I want to point out on the resolution that you're about to take action on is we did request some additional stormwater calculations and related items from the developer and his engineer, and we just got that this morning. So we specifically worded the resolution that the plan, or that the resolution allow us for time to review that and make sure that that work is perfected before plating happens. So we did.
So I'll have the motion. I'll ask if the motion can be amended to.
No, that's the way we wrote the resolution, to allow that.
So it's already included in the resolution
So-
that the stormwater will be approved by you guys.
So there's a contingency in the resolution that says that stuff has to be perfected before plating can happen.
Okay, sounds good. That way we're not getting in the way of the construction or the development. Any other discussion? Seeing none, I'll ask for a vote. All in favor, say aye.
Aye.
Opposed? Motion carries. Item number 6 is the plat of the East Park Second Edition.
You don't need me anymore, right? I don't have a canopy on either.
And also in that resolution, we'll include we'll look at the sidewalks upon
Yeah.
building permits.
Right. We didn't in any way waive the sidewalk requirement on Lot 6.
Okay, so for the plat of East Park Second Edition, petitioners submitted plat and plat certificates on January 11th, requesting approval of East Park Second Edition. The preliminary plan of East Park addition was approved by resolution 2015-19 with conditions on June 18th, 2015. So this is the plat that they're proposing. Okay, so I guess we can just go right into the conditions that our concerns are, or that Shane will touch on.
Now, can you back out on this one a little bit and show us exactly where it is in that Willow Creek in comparison to the Willow Creek? Is this the Morris property?
No, this is Coho.
Coho, formerly Little's addition.
Okay.
I can pull it up on the GIS.
So the preliminary plan for this development was approved in 2015. It was something that this board took action on sometime, I think, in May or June of 2015. And so this is the ultimately, the plat that's coming forward out of the resolution that was signed. In fact, the resolution that is related to this plat is the 18th of June 2015. So with that, I guess I do want to make reference to that resolution that you passed on June 18th of 2015. As it had several points, 11 in fact, that were tied to that approval of the preliminary plan, and there are a few items that have changed since that resolution. One is the developer and city staff are working together to create a regional pond that would take care of the water quality and the 2-year stormwater retention and management. And so that essentially is not a part of this plat any longer. However, it's up to staff to make sure that this city's stormwater provisions are accounted for. And so we're working for a new location for the storm pond. It's not going to be contained within the platted area that you're looking at today, but it's going to be a better end result for the city and the community where this stormwater pond will end up. So I can ask more or answer more specific questions if you have them.
You've talked about that before. You and I have talked about that before. Wouldn't it be nice that if each small area didn't have to retain their own water, if there was more of a regional area and they all contributed to that area, and that's what you're working with them on? And you're comfortable with that? All lots compliant, Brandy, as far as size, setback, width, length?
Yep, and then they revised their easements to meet utility standards.
Okay.
The access points were another concern that were addressed on the resolution. And we made sure to account for that in the certificates, that they would be allowed 2 driveways per block face, with the block face defined as no less than 300 feet or 330 feet. Just because in their preliminary plan, what they showed that got approved, that was there was more driveways than you guys were willing to, or the board at that time was willing to accept.
Okay. And they've met those conditions that we required?
Yeah, they signed. That'll be in the certificates.
Okay.
We approve the final number and location of the driveways upon building permit application, but your resolution defined how many driveways there should be. So
all right.
We're conforming with that.
Thank you. With that, I'll close. Does anyone else speak in the public hearing? Seeing none, I'll close the public hearing. Ask for a motion and a second on resolution 2017-08.
I'll move.
Dennis? Second by Mr. Hanson. Any other discussion on it? All in favor say aye. Opposed? Motion carries. Item number 7, old business A, Stony Point 3rd edition discussion.
We received a plat of Stony Point Third Edition, and let's see, let me pull- so we held a design review team meeting on February 2nd, and we also received a plat of Stony Point Third Edition in July 2016, where we sent the developer and property owner a letter addressing our concerns with that plat. And we can compare the two later in the discussion. But basically, our design review team takeaways was that we'd like to prove that the easement road can support 75,000 pounds for fire code, and if they were to rescind their current preliminary plan of Stony Point that was approved with conditions, and then potentially resubmit a new preliminary plan of Stony Point.
Now, we approved a preliminary plan, but the city council did not, correct?
Right, and that's all, Plan Commission only has to, for preliminary plans.
Well, actually, the council does approve the plats that are a resultant out of the preliminary plan, and that was voted down at the previous council meeting. So what, where I'm at with this, or the reason I brought this up for discussion is what we're receiving from the developer are smaller portions of the preliminary plan, but don't address all of the issues and don't have full compliance with the preliminary plan that was passed by this board. And so what I'm struggling with and trying to get direction from, so I give the developer and his engineering staff some type of feel for where or what we think can happen. I'll just give you, for instance, and we'll toggle back and forth. So this is the current plan. Oh, okay. Is it? Okay. So this is a variation of the preliminary plan, and all it really essentially does is wants to define 3 more residential lots. Issues with it doesn't designate any more public right-of-way, which would comply with the preliminary plan. This is now called a access and utility easement, as well as this area is here. So fundamentally, we have some concerns with that and are not recommending this version of the preliminary plan. Can you go to the previous one that we had?
Yep.
So earlier this year, this was the version we got, and our response was that it still didn't conform completely with the preliminary plan. And essentially what's different is it's only a portion of the preliminary plan, and it doesn't account for that second roadway out that we had discussed and things like that. And where we're at as a staff is we recognize all the effort that was done in the previous planning commission meetings and all of that did direct it to get to that more full-blown, complete development of the whole area. And now what the developer's indicating to us is that he no longer wishes to develop the whole entirety of the area. He just wants to get a few more lots on the top. This, in our current version that we have to consider, this block 2 is now an outlot that encompasses the whole lower half of that. And what's still frustrating for me as a director of the staff, and we seem to have pigeonholed the whole area into one concept. And my response to the developer is getting more difficult because we're just automatically, categorically saying no. each time we receive something. And I think what I want you guys to weigh in on is ultimately someday, and if you can go to the GIS drawing, Brandy, that would be helpful. And go over to that. Okay. Let me. Where I'm coming from is that this whole area from Lake Drive over to Hidden Valley will have an ultimate footprint change of whatever that is. I mean, and that's the decisions that come through us as staff and you guys as a plan commission. And right now, Stony Point sits on an island because of undeveloped land in between Lake Drive and the Stony Point property. But someday in the future, whatever that is, whatever future that is, at least for me as a city planner, I think there's going to be a roadway that bisects over to Stony Point from Lake Drive. There could be 2 roads. There could be 3, depending on who ultimately decides to develop the space between it. And so what I'm asking is, what is the wishes of the board? I mean, we've had this previous design that took a roadway all the way down through Indian Hills. Is that right? Or Prairie Hills, excuse me. Indian Hills is Sioux City, Iowa. Sorry, thinking. But Prairie Hills development, and I still could accept that as a ultimate plan, but if that never happens, we are basically freezing anything and everything up there. And I'm not just worried about new lots, which is what's being proposed up there. We're also going to have very minimal service that the city can provide to the 5 lots that are already developed up there. So I'm just bringing this out for discussion. I can keep categorically saying no to things that don't align with that previous preliminary plan, or what I'm kind of want to steer the conversation to is maybe we need to abandon the other preliminary plan at some point. Actually, it becomes null and void in 3 years anyway, but how are we going to get from Lake Drive to Stony Point into some future? And I believe that I need to be able to tell somebody that, and instead of just saying no, I'd like to give them a little bit more than a "I'm sorry" answer, or you know. And I think I can say with a fair level of confidence that the idea of the channel is behind us. I don't think that there's going to be a proposal for another channel. In fact, he's kind of I think that would be content to just do a very minor development here, but with the preliminary plan that I have to consider now, it doesn't apply.
And this is just discussion. We take
Correct. Yes,
we take no action. So this is just Shane just wants to kind of take a temperature of the board.
Yep.
My opinion is, when we develop, we normally develop from the inside out. This is being developed from the outside in, where we have the farthest lots first. As I understand the way this has been developed in the past, there's an easement from an adjacent landowner that applied to 2 lots. There was one monster lot there, and there was an old Forestburg lot. The Forestburg lot, that property on the end of the point, if you want to zoom in there, was purchased and some right-of-way was platted on top of an easement, which incorporated those lots. And that's what we've seen, where we've seen the development so far. But, to me, it's simple. We don't allow construction on gravel roads. We require a hard surface road that's turned over to the city when it's done. And they got to figure out a way to get a hard surface road. Either Door Avenue gets extended. They purchased the easement road from the adjacent landowner and and make it a hard service road, or they bring us a hard surface road in from the south. But, if we start letting developers develop lots on gravel roads, we've opened up a Pandora's box, and it's not fair to everybody who's developed in the past, my opinion anyway.
Okay, so in the meantime, one house has been built up there, and we are providing city garbage collection. And in fact, we're collecting garbage for this house down here. The house that's on this lot will be collected, and garbage will be collected on that. That is not the easiest way to maintain that city service without further development.
So two wrongs don't
why
make
is
a
that-
right. We can't put seven
But
more
why
houses
is that
up
being
there.
done? It's not done anyplace else in town. Why is it being done there? We all know, we go back,
Correct.
the one house that was up there, why it got started.
But everybody in the city
But-
limits pays a garbage fee regardless if you put a can out or not.
You go down on South Lake Drive by the water tower, and those lots lay way down. There's a lot of right-of-way between them and the highway. They have to drag their garbage cans out to the road.
And that may be, I can't
But-
answer why but I'm just saying that that's what's happening now.
Well, that's because the precedent was set, 50 years ago, I suppose, but
but,
on that one lot, but,
So, anyway, I just want to have
yeah.
this frank discussion as to what this board wants to see us respond to out here.
I think they need to pursue getting a hard surface road in there, either from the south, from the east, or from the west. One way or the other, they got to get a hard surface road in there if they want to continue to add more lots and more traffic up there. If we allow access through a 20-foot gravel easement, and I know the adjacent landowner probably isn't very happy with what's going on up there now, and they'll be less happy. To me, the spirit and intent of that easement was for 2 homes. And that easement was given years and years ago, and now if all of a sudden, due to one loophole over another, we've got 7 homes and 2 commercial lots up there, it's not fair to the adjacent landowner. That wasn't what they bought into. My opinion.
Well, and as a developer, there are many developers within the city of Watertown, and in every one of those developments, there is some prime property. If you take Hoff-Teasers up north, Northridge, whatever it's called, those lots out along the bluff, those are prime lots. But they were not allowed to develop those lots and sell those lots out overlooking the bluff until they worked their way back to it. And that's happened all over. I don't know how you can set a precedence and let one person do it and turn 7 others down for the last 20 years.
I just look around town. We have gravel roads in town, and we struggle to get them paved because we can't get the adjacent landowners to agree to it. And there might be people up there that say, I'm perfectly happy with it the way it is now. But thoughts on this end?
I'm with you.
I'm with you.
And sidewalks for that matter too. I mean, I don't want to be piecemealing this together and then skirting some of the requirements here and there, and then we end up with something that's worse than the vision that we were looking at before. So.
Any other questions? Any other
Okay.
comments?
So.
We're not, he was in here and he agreed more than once, I will not plat another lot until there's a hard surface road up there.
Right, so.
And
that's-
his plan of a channel didn't go through, so now he's coming back in and saying,
okay, so
no.
That will be a clear,
I think
concise
so.
answer from us. I just wanted to make
Yep.
sure that.
I think it's
that's
fair.
exactly what we want to do.
This is an area that was developed from unintentionally. If we could do it all over, I guarantee we wouldn't have put those lots out there and we would have made that decision. The reason we did it was those lots, the owner of those lots said, I want to plat these and I can't master plan or preliminary plan this area because I don't own it. In this case, there is an ownership there. He doesn't have to put 35 lots in there. He just got to get a hard surface road to his development. And he happens to own almost all the land between there and in one direction, he does own all the land from the hard surface road to his development. But from the south,
No, he doesn't.
funny.
Right.
We had H lots that were being designated from Prairie Hills that would have accommodated a road. That does not equate to ownership.
Okay. He had an agreement
Correct.
that it could go through there.
Right.
There is an option to get that road up there.
But clear ownership was never
Okay.
involved with that.
He doesn't own from the Dora side, and he doesn't own from the easement side.
Correct.
So, all right. Next item was an update on the,
He did, let me just say this, he did purchase an easement. He did pay for an easement to come in from the south.
Right, but that's not real property.
Right, yeah.
old business B was an update on the garage district maximum sidewall ordinance adjustment.
Okay, so this is just to get whatever you guys are thinking, then I'll bring it to the next plan commission meeting as an ordinance amendment. But the takeaway from the January 5th initiation of discussion to amend ordinance 2123, you guys suggested to raise the maximum sidewall to 16 feet, change the written consent percentage to be 55% instead of 100% of all property owners owning property immediately adjacent to the proposed zone, allow sanitary sewer connection, and then to leave the finishes for structure aesthetics to the building's official's discretion. And as far as the maximum sidewall, staff would recommend 12 to 14. It's currently 10. And then we agree with the consent percentage change to 55 instead of 100%. And then staff feels allowing sanitary sewer could be difficult to regulate if that's allowed in that district.
So let's roll back through them kind of one at a time. And we're talking in the garage district. We're not talking just rampant in the R1, R2, R3. We're talking just in the garage district.
Yep. And I did take pictures of various garages too, if you
We
want to
should,
go through
yeah,
that first.
yeah, let's do that. When I talked to Brandy on this the other day, happened to be up in the north part of town, and there's a couple homes up there that we've worked on in the past, and I drove by them, and there was a couple things I saw in there that I thought would be interesting. So she went out and took some pictures for us.
Keith and I went out there. So what that number on top is addressing is the sidewall height. So here we're 10 foot.
And where's this home located? Where was that first home located at?
This is on North Lake Drive.
Okay, gotcha.
What's the sidewall height, 10
10.
on that one?
Yep. So, and this is what we allow right now in the RG district.
And part of the thing I asked Brandy on is that when I happened to be parked outside a house, I said, a higher sidewall looks aesthetically better if it's a percentage of the height of the house. Meaning if you had a one-story Rambler with 8-foot sidewalls on the house and you had a 14-foot sidewall garage next to it, it would look odd. But if you had a 2-story house or a 1.5-story house or a raised ranch where the roof peak was somewhere between 24 and 32 feet, and then you had a 14-foot sidewall with a peak that was at about 2/3 of the height of the house, which you may show here, it didn't look out of place as it could be in some areas.
But our only issue with the RG, and I thought about this after our conversation, is that
There are no houses.
there's no houses on
Right.
the lot.
But there's houses across the street.
Right.
Where's
This is on North Lake Drive. And this was one that came to the Board of Adjustment.
this is the one that we allowed this outside one up a little bit, didn't we?
Yeah.
It was-
'cause if you would include the foundation, I think it would be higher than 10 foot. Is that correct?
But you only include the foundation at the front.
Oh,
At where you go into the garage. You measure from there to the peak is the point you measure. That's 18 feet. Realizing that there is hills and so the back side of the house could be 20, 25 feet depending on how steep of a hill is.
okay.
So the only part you take when you adjust for the 18 feet is where they drive into the door and to the peak at that point.
So you're measuring 10 feet from the garage door.
We're
where
garage,
that
yeah,
is.
10 feet. Well, but for inside, for the wall height, it's from the finished floor of the garage.
Yeah,
The
prevent
finished floor of the
somebody
garage
from
to
putting
the
four
top of-
courses a block and then 10
Yeah,
feet.
no, the four course block would be.
But it's
coming
okay
in.
if the four courses a block are in the back because of a slope.
Yep,
Okay. But still, the sidewall was 10 foot.
yeah, correct.
This was a 12-foot sidewall.
Where's that one
This
at?
is also, I believe it's still on North Lake Drive.
We gave him a variance? Never mind.
I don't know.
I don't know where that one's at, I'm sorry.
I think, yeah, it's way over on North Lake, the old Herzog property.
Kind of across from Redmond. He's on the opposite side of the street. Chad Redmond. You know what I'm talking about, where he's got his,
This one.
he's got that one right, that's his building across the highway.
That's not in the
That's in the
city limits,
it's in the
correct?
county.
That's not in the city limits.
I just wanted
That's
this for
Luke's.
perspective.
That's Luke's.
This is from perspective.
Because here we're at 18 to 20-foot sidewall. We weren't for sure. But then 16-foot overhead doors.
And conceptually
why
with that is, where is the garage district located? If the garage
Right.
district is located in an area where it's really not close to residences, maybe you could go with higher sidewalls.
But see, that garage, the one you just went away from, that could look totally different with a few minor changes and look very attractive. Right now, it looks like a big, tall box.
Right.
Wouldn't take much to get that garage looking nice, that everybody would agree with.
Nicer. It still looks nice. Somebody's garage.
This is a 10-foot sidewall, but this is kind of where it would tie in aesthetically with the house or building materials.
And where's that one at?
This is, gosh,
That's that one that used to be flooding down there in that corner. What's clear over on the other side? Beer sheds, yeah.
Okay, that's
Yeah,
down in
he el-
Marina Bay, near Marina Bay.
Yeah, he elevated
That's
that
10
whole
foot,
thing.
that's, okay, that's a 10-foot, which is current code.
yep. Yeah, I threw some of them in here too, and just because they looked nice. And then this would be the same thing where in the back, it has some exposed block, but that doesn't matter. It's just, this is 10 foot, 8, 12 sidewall. And this is on South Lake Drive?
That's still on North Lake Drive.
Oh,
Most of these are on North Lake.
Arnold, Dennis? Wait, this is your building, right?
Yeah.
Oh, that's,
And what's,
yeah, that's Tony's.
Oh, okay.
what's the sidewall height on those, Dennis?
See, that's what I
The
found
sidewall.
interesting about it, because then you can see the comparison between.
And what he did here is the sidewall height can, this is the front, so the sidewall height isn't really measured where these doors are, they're measured over on the side, correct? Because these doors these are dormers that come out.
That particular garage on the right side of that would have the 16-foot sidewall, right where she's outlining there. The rest of it would be lower. But see there, you've broken it up. And it's different.
It's kind of a dormer effect that's coming out in the garages in the dormer. You put scissor rafters in there then? Scissor
That has-
rafters to
well,
get that added
has
height?
Scissor rafters in there too, in that garage, yeah.
But that's an example of breaking up the building and the looks of the building by what do you call that when you bring it in and out?
Different roof pitches.
Well, not the roof, but the sidewalls. The actual sidewall is jogged in and jogged out.
That's what we were talking about, Pat, the last time on that sidewall articulation, I guess is the term that other communities have used.
Yeah, yep, you brought that up last time.
This is a 12-foot, which is very aesthetically pleasing.
Where's that one at?
That's in Prairie Hills too.
Yeah, and to me, like I said in this one, the roof heights match. The roof height isn't as high as the house is, especially because of the slope of the land.
Katkin had come here
Okay.
for a variance on that one.
Did he?
Yeah.
And
He
we
did.
gave it to him, and
Yep.
it turned out nice. It's not one that came back to haunt us.
This is
And
the,
see, he had to have a variance because his camper's not very big, but that center door is taller. So we had to have a higher sidewall to get his camper in.
So again, he put a little dormer there to get that extra. His door
To
is
get-
the same
to get
height
that
as his
higher
sidewall.
center stall.
This is the garage that currently exists in the RG district.
Where's that at?
Pheasant Lane. Okay,
And this is a 10-foot sidewalk.
Okay, so that was built without variance. That's just a simple building permit, met everything.
Yep,
And we rezoned it to RG.
yep.
So that went from R1 to garage district.
So, I mean, really, when there aren't houses around or anything, then this building is pretty hidden too, where it's not, I guess a taller sidewall wouldn't be completely obtrusive. This is an 8-foot sidewall with 2-foot, so 10-foot sidewall.
it's out on East Kemp.
Must have put
Or,
some, changed his rafters again to get that door in there.
He came before the board too. That's on Third Avenue, all between.
What do you have to come to us for?
Um,
Wasn't the sidewall height
Be a roof pitch, probably.
No, there's a rip his matches.
setback probably?
His front setbacks, I think he was oversized.
See, that garage must have parallel trusses on it to get that big door in there.
This is 12-foot sidewall,
Where's that at?
up by lake area.
But that one's close enough to the building where it's considered attached.
And that one to me it's taller than the house. That looks a little out of place.
Oh, and that, isn't that Sears
Yeah.
on Third? Yeah, no, he came before the board too and you gave him a variance.
That didn't look like the diagram.
This wasn't supposed to be a shaming.
This is one I told Brandy to take a picture of, and this has a 10-foot sidewall, but look at the difference in the size at the peak of the house.
It actually looks
Looks too small.
too small.
You know, they could actually go a little higher, and it still wouldn't look out of place. That was up on the northeast part of town.
Yeah.
Right off Grandview.
Now this one is a good example of why having a taller sidewall would be nice, is because they couldn't even fit their shack in there and clean up the outdoor
And what's a
storage.
garage worth if you can't fit your ice shack in?
Right.
I'm with you there.
And this was the latest one that came in front of the board. And I think this was because it was oversized, because it still has 10-foot sidewalls. Oh. And then here is another thing for perspective, is over here we have 16-foot sidewalls and 14-foot doors, and then this is 14-foot sidewalls and 12-foot doors.
But that one's attached and it's only limited by the 35-foot rule.
Yeah, but yeah, that was just for perspective. And then this is 14-foot again, but then here, you know, they dressed up the front where it doesn't look.
Where's that one at?
This is Sign Pro.
Okay. Flip to that other picture, because that came before us.
That's the backside.
But their addition didn't really have anything to do with the garage.
So that's the slideshow of that, if that gives any enlightenment or.
So where did the staff end up on the sidewall height?
They like 12 to 14. Go back to that original bullet points that you started with. We can kind of go through them one at a time and see what everyone thinks.
How high is the motorhome, Dennis?
Well, you have to have a 14-foot door to get any size camper in. It's a decent
Because that's
size
what's
camper.
running in.
You got your air conditioners on top, so you got it.
It's like, you know, Model T garage compared to a triple garage today, you know? You
Yeah.
gotta have a bigger garage these days. Cars are bigger.
If you don't give them a 16-foot door, you're still gonna end up with those big campers and things sitting outside.
Right.
No place to put 'em.
Right.
And we're talking in the
So why are we
garage
talking
district,
why are
not
we
in the
talking
R1
14?
district.
Huh?
Why are we talking 14 then?
Well, you can do a scissor truss.
Well, we were,
He was talking 16.
We suggested 16. Staff's coming back with his 12 to 14.
Well, if we got a camper problem in Watertown, why were you suggesting 14 feet?
That's my point.
Okay.
That's been my point all along.
But
The only thing, you can take a 30-foot wide building, 14-foot sidewalls, and do a scissor truss, and you can still put a 12 by 14-foot door in there.
And then you're limited to the design.
Well, but it's not, you're creating one stall for the camper, you're not creating multiple stalls.
It makes completely no sense to me.
we remember now, you're only talking about the RG district. You're not talking about every garage that's being built adjacent to any house in town.
That's why this
why
is
we
an
have a
RG
problem.
district. That's why it ought to be different than a residential area. That's what we're doing in RG districts for.
In that
So we
RG
get our
district,
stuff in
we
there.
require them to use the same
I see some
building
heads nodding in the back.
materials.
Why
as the
even
homes.
mess with it if you're not going to make
Well,
it
the main purpose of the
accommodate what
RG
needs to be
district
put away?
to start with was to allow people to have garages, an accessory structure without a primary
Without a
structure.
house.
You,
That was-
you
yeah.
made the RG district to determine a garage is now in a primary structure in that location, so they can do it and put their toys and stuff in there.
If people want the lake cleaned up out there, they have to have 16-foot sidewalls.
If that's what you guys want, that's great.
You know, and we're only talking in the garage district. We're not talking in the R1 district. Across
And
the
I
road.
wouldn't have any problem if you're going to have a 16-foot sidewall, then you can put some various other things involved in that, how it's designed a little bit, rather than just 4 walls, 16 feet tall.
But it's in the garage.
There's things you can do. What?
But it's in the garage district. But the garage district is adjacent to an R1 district. That's why we have to be conscious of how the design looks and how they're going to aesthetically look. There's a big difference between doing it as cheap as you can and as some guys can put a crazy amount of money in, some don't. So let's keep moving through the bullet points of what you guys talked about. Sanitary sewer. What was your reasoning for not allowing that over there?
Well, originally we had no sanitary sewer, so it wouldn't turn into a primary residence as a house. That was the thought, trying to keep it out of the possibility of probably all of a sudden just doing an RG and
So they don't
now
live
it's
there.
their home. But I agree. It's nice to have a bathroom. It's nice to have a place to clean up,
Nice to have
Nice
something
place
to
to
wash your stuff is
clean
kind of
your
what I was
fish,
thinking.
or take a shower when you come in from hunting. I don't disagree with that. We allow that in an unattached garage on the primary residence.
Do we in a sense then in that garage district ordinance specifically say no living quarters?
I don't know if we
Will-
put that in there because we
will that
deny
do it?
the sewer. If without sewer you can't have it. But
Right, but if we allow, I can see if
We would have to specify no living quarters.
of some sort, that way they could still have a bathroom and a sink and canned pickles there if they want.
Within the other one, you allow no kitchen and no sleeping room. That's what our unattached garage is.
Okay.
It'd have to be similar to that then.
I'm not adamant about this, but if you're building that to put a 14-foot tall camper in there, there's your living quarters, people. I mean, somebody could live in that building in a camper.
Or they live outside the camper for spillover,
And I think there it becomes a problem for Chip. I mean,
Well, we just have to put, you can't inhabit the garage district, whether
there-
you're in a camper or you're in a.
There you're making
on
a
a
rule
cot.
for somebody who might try to stretch it and abuse the intent of everything, but you're limiting everybody else in the whole community for putting their camper away.
That's exactly the caveat that you're in
Yeah.
right here. Yep.
I say you just
have
can't
to
live
deal
there.
with the person that wants to pull his motorhome in there, and stay in his motorhome all summer long, and then in the fall he takes it to Arizona. If that's what they're doing, come on, they're abusing
No,
this thing.
and I have friends that have done that in other communities, so I'm not a judge. I'm just saying that's
No, but I mean, you
that's
just have
what
to
you
deal
gotta
with
be
that if that's-
recognize. Yep.
You want to have a sewer in there so you can dump your camper.
You can dump it on the driveway. Oh, that's Would you rather have that? Your grass would really grow.
So what safety measures do we have in there to make sure that the buildings are built aesthetically correct? Did you guys put anything in as far as, what did you say earlier, Blake? What did you say? Articulating or something?
You said that so good a month
Yeah.
ago. Say it again.
Did staff look into that at all, sidewall articulation?
Randy, I thought you went out and researched it in some of the other communities.
Justin just pointed out, in the residential garage district.
You know what I'm talking about, where they had to do some kind of other design instead of just doing a straight 16-foot wall.
One example, one example that goes out there is it's basically, you only get so many feet that are at a flat height, and then you've got to change your height. One of the examples I looked at was 32 feet. You can't have a span of 32 feet without a change in height on sidewall. It's an example, or else whether or not it's a change in building materials as well. But there were no examples put together. It doesn't look like, but it's really, I mean, the book's open. I mean, one of the things that I was looking at that makes sense is that if you're thinking of going to a 16-foot sidewall, my own, and don't get me wrong, I don't take a camper up and down the interstate, but you can't drive a camper on the interstate if it's bigger than 13 and a half feet. And so I mean, I don't know, there might be some that are bigger than 14 feet, but it's supposed to be road legal at 13 and a half. But the point is, if you're going to have, maybe if you want to do that 16-foot span, maybe it can't be, maybe it's only a portion of it can be that high, that size, which goes back to what I guess you've talked about before, Dennis, and that sort of thing. There's some examples of things that you could do.
And that's what I could, when I write the ordinance amendment or put the things that you guys would like to include, I mean, we could come up with language for the sidewall articulation and aesthetics. Because right now what we were thinking is that as far as the building aesthetics, that we leave that up to the building official's discretion. But we would include some guidelines then as far as how you guys would like them to look aesthetically.
I think we can do that. Justin did state that in the garage district there is some verbiage that doesn't allow any living in there. We already have it in that.
Yeah.
So that prevents people from living in a camper or living on the site.
Yeah, that does not contain a residential dwelling unit.
We just have to enforce it, if it were to happen.
What I was going to say, I suppose if there's a lot of consternation or really concern from staff, 16 versus 14, seems like maybe there is. Seems like we're a little bit on the opposite side of the fence on this, but then maybe you can say that if they want 16, it can come before this board and based on of course, then it gets pretty subjective, I suppose, on your part, but the design of the building might allow whether you can bump it to 16 over 14. But at least the door's there.
Because that allows us, like
and then you can
Luke
raise
said,
it 2 more feet.
Yeah. Like Luke said, if there's too much flat area, we could say, well, you can go 16 this far, and then you've got to drop it down or articulate that.
I will tell you, so as not to confuse the variance process, it would be wiser to list that as a certain type of permit, as a conditional use permit with anywhere from 1 to 7 conditions or whatever. You just list what those conditions are that you would like to see, and that the board reserves some discretion if you want. But the point is that it would be wiser, just for my own suggestion. Don't do it as a variance, do it as a conditional use or as a special permit.
Yeah, that probably makes sense.
Yeah. Agreed.
Yeah, it's like Luke was saying, and I know St. Cloud is one of the ones that had the sidewall articulation, and it was, over 32 feet in continuous length, with no jog in it or no dormer. Then you had to put some sort of feature in like that. So, and it gives them a guideline if you have that written in there too, so that if they're reading over the ordinance, they kind of know what they need to be shooting for before they even come before Ken. So.
Any other discussion on that? All right.
The only thought is
Hey, we already got you out of hot water once tonight.
Wow, yeah. I'm trying to throw me back in. Because you can still leave it at the building official's discretion and with the aesthetics of what you're looking for. Because even if I do tell them no, then they still have the right to come and see you guys anyway and say, well, hey, I want to do it like this, and I think it's dumb that I have to put a 2-foot by 12-foot siding on there with a little eyebrow to make it look good. I don't want to do that. I just want a box. So
I think we can make something then. And I also look and even in the R1 under certain circumstances, I could see a 12-foot sidewall depending on how the house is the layout of the house, the height of the house, and, you know, there's some cases, you can see that 10-foot is limiting in some areas, and if you got a 2-story house or a story and a half and it looks like it belongs there.
I am getting more and more and more requests for more than 10 foot. I mean, we moved it to 10 foot from 8 foot just because the change in the culture and the trucks and everything else is getting taller. And I'm not objecting going from 10 to 12. You know, that's
I think we get
culture
the
is
garage.
changing, and
Let's get the
we're trying to-
verbiage in the garage district right, and then I think we do tackle the R1.
I'll bet the 10 started when everybody had 8-foot ceilings, and 2 foot of foundation. Therefore, your garage can be 10 foot. That's where the 10 foot probably originated, so it's similar to your house. Well, that's not the case ananymore.
Well, I've seen some pickups that
When's the
struggle to
last
get
time you
into a
built a house
7-foot
with an
garage.
8-foot ceiling?
Yep.
Put a lift kit on.
Yeah, you put just a 4-inch lift kit on a big 1-ton truck. I've seen them go into those old garages, and I'm thinking, yikes! You better make sure that garage door went all the way up.
I think the majority of us like the 16 foot, but what we do not want is a 16-foot sidewall, no overhang on the gable end, and 12 inches on the side. That we don't want.
So, yeah, as long as we get the wording, the language in there right to make sure that,
You know, and I think we'll probably see some of these. You know, I'll be honest. I thought these garage districts would be a hot item. I thought every developer who's developing new land would set aside some land for garage districts, and maybe once we dial this in, we'll start seeing more of those garage districts, because there's a lot of land out there that could easily be modified to one.
Yeah.
There's a need out there, that's for sure. All right, with that, I'll ask for a motion to adjourn. Motion by McGuire, second by Hanson. All in favor, say aye. Opposed, motion carries.